Viva Guide on the Specific Relief Act. Question: what is the name of the act? Answer: this act may be called the Specific Relief Act 1877, Act No. 1 of 1877. Question: how is specific relief given? Answer: according to Section 5 of the Specific Relief Act, specific relief is given: number A, by taking possession of certain property and delivering it to a claimant. Number B, by ordering a party to do the very act which he is under an obligation to do. Number C, by preventing a party from doing that which he is under an obligation not to do. Number D, by determining and declaring the rights of the parties otherwise than by an award of compensation. Or number E, by appointing a receiver. Question: describe suit by person dispossessed from immovable property. Answer: according to Section 9 of the Specific Relief Act, if any person is dispossessed without his consent of immovable property otherwise than in due course of law, he or any person claiming through him may by suit recover possession thereof, notwithstanding any other really title that may be set off in such suit. Question: in which case is specific performance enforceable? Answer: according to Section 12 of the Specific Relief Act, except as otherwise provided in this chapter, the specific performance of any contract may, in the discretion of the court, be enforced: number A, when the act agreed to be done is in the performance wholly or partly of a trust. Number B, when there exists no standard for ascertaining the actual damage caused by non-performance of the act agreed to be done. Number C, when the act agreed to be done is such that pecuniary compensation for its non-performance would not afford adequate relief. Or number D, when it is probable that pecuniary compensation cannot be got for the non-performance of the act agreed to be done. Question: which contracts are not specifically enforceable? Answer: according to Section 21 of the Specific Relief Act, the following contracts cannot be specifically enforced: a contract for the non-performance of which compensation in money is an adequate relief; a contract which runs into such minute and numerous details, or which is so dependent on the personal qualifications or volition of the parties, or otherwise from its nature is such that the court cannot enforce a specific performance of its material terms; a contract the term of which the court cannot find with reasonable certainty; a contract which is in its nature revocable; a contract made by trustees either in excess of their powers or in breach of their trust; a contract made by or on behalf of a corporation or public company created for special purposes, or by promoters of such company which is in excess of its powers; a contract the performance of which involves the performance of a continuous duty extending over a longer period than 3 years from its date; a contract of which the material part of the subject matter supposed by both parties to exist has, before it has been made, ceased to exist, and save as provided by the Arbitration Act 1940, no contract to refer present or future differences to arbitration shall be specifically enforced. But if any person who has made such a contract other than an arbitration agreement to which the provision of the said act apply and has refused to perform it, such contract shall bar the suit. Question: which instrument could be rectified? Answer: according to Section 31 of the Specific Relief Act, when through fraud or a mutual mistake of the parties, a contract or other instrument in writing does not truly express their intention, either party or his representative in interest may institute a suit to have the instrument rectified. And if the court finds it clearly proved that there has been fraud or mistake in framing the instrument and ascertain the real intention of the parties in executing the same, the court may in its discretion rectify the instrument so as to express that intention so far as this can be done without prejudice to rights acquired by third persons in good faith and for value. Question: who can cancel a written instrument? According to Section 39 of the Specific Relief Act, any person against whom a written instrument is void or voidable, who has reasonable apprehension that such instrument, if left outstanding, may cause him serious injury, may sue to have it adjudged void or voidable, and the court may in its discretion so adjudge it and order it to be delivered up and cancelled. Question: narrate the discretionary power of courts to declare status or right. Answer: according to Section 42 of the Specific Relief Act, any person entitled to any legal character or to any right as to any property may institute a suit against any person denying or interested to deny his title to such character or right, and the court may in its discretion make therein a declaration that he is so entitled and the plaintiff need not in such suit ask for any further relief. Question: how long a temporary injunction can be given? Answer: according to Section 53 of the Specific Relief Act, temporary injunctions are such as are to continue until a specific time or until the further order of the court. Question: for which perpetual injunction can be granted? Answer: according to Section 54 of the Specific Relief Act, subject to other provisions contained in or referred to by this chapter, a perpetual injunction may be granted to prevent the breach of an obligation existing in favor of the applicant, whether expressly or by implication. Question: why mandatory injunction given? Answer: according to Section 55 of the Specific Relief Act, when to prevent the breach of an obligation, it is necessary to compel the performance of certain acts which the court is capable of enforcing. The court may, in its discretion, grant an injunction to prevent the breach complained of. Viva guide on civil appeal and civil revision. Question: which sections of Civil Procedure Code provide for provisions of civil appeal? Answer: Section 96 to 112 and orders 41 and 43 of the Civil Procedure Code provide for the detailed provisions of civil appeal. Question: what is the nature of civil appeal? Answer: as far as the Supreme Court procedure is concerned, civil appeal, like criminal appeal, is a non-motion matter, and you need not need any affidavit for filing the memorandum of appeal. Question: why is the word first appeal still used? Answer: before the enactment of the Law Reforms Ordinance 1978, there was difference between first appeal and second appeal as provided in Section 96 to 103 of the Code of Civil Procedure. However, the Law Reforms Ordinance 1978 abolished the provisions of second appeal, and there is now only provisions of appeal from decree, Section 96 to 99, and appeal from orders, Section 104 to 106. It is therefore is not appropriate anymore to use the terms first appeal and second appeal. However, many second appeals filed before 1978 still remain to be heard and decided, and those appeals are still known as second appeal, and hence the term first appeal is still used. Question: what do you mean by the term second appeal? There is no provision of second appeal in law anymore. Sections 100 to 103 dealing with provisions of second appeal in the Civil Procedure Code have been omitted by the Law Reforms Ordinance 1978. Question: what do you mean by civil miscellaneous appeal? Answer: there is no information with regard to miscellaneous jurisdiction of High Court division in the rules of High Court of Judicature. It is the civil rules and orders which provide some guidelines with regard to miscellaneous jurisdiction. Chapter 34 in Part 7 of the CRO provides 4 categories of cases. Number 1, suits and appeals from decrees. Number 2, miscellaneous judicial cases. And number 3, miscellaneous non-judicial cases. And number 4, miscellaneous appeals. Section 774 of the CRO in Part 7 of the Chapter 34 provides that following are classed as miscellaneous appeal. Number 1, appeals from orders under Section 104, subsection 1, Order 43, Rule 1. Number 2, appeals in miscellaneous judicial cases. Question: what do you mean by cross appeal or cross objection appeal? Answer: where the decree passed is partly in favor of and partly against the respondent, and such decrees appealed from, the respondent can take such objection to that part of the decree which is against him as he could have taken by way of separate appeal. Such objections are called cross objections and are filed in the form of a memorandum, Order 41, Rules 22. In cross appeal, the decree of the lower court is partly in favor of and partly against the respondent, in which case both the appellant and the respondent may separately appeal to the higher court to set aside that part of the decree which affects him adversely. If each of them appeals, we get a case of cross appeals. Question: what do you mean by the term tender of appeal? Answer: you will often see in the daily cause list many references of FAT or MFAT, etc. FAT means first appeal tender, and FMAT means first miscellaneous appeal tender. All civil appeals are filed by submitting a memorandum of appeal. When a memorandum of appeal is filed in the section, people will give you first a tender number, and this is why every appeal in the first place is called an appeal tender. There is no proper answer why this happens. One view suggests that this is for departmental flexibility in the section. The section people needs to verify whether the memo of appeal is in correct form or not, whether correct court fees have been paid or not. And to do this, section people need some time. However, before this verification is complete, the appellant may want to get an urgent injunction from the court, and if no number is given, how can he mention in the court of or file an application for injunction against this appeal? This is why a tender number is given once a memo of appeal is submitted in the section. Subsequently, a proper appeal number is given when you will get the appeal admitted from the open court by way of mentioning. Question: what do you mean by memo of appeal? Answer: Rule 1 of Order 41 of the CPC provides that every appeal shall be preferred in the form of a memorandum signed by the appellant or his pleader and presented to the court or to such officer as it appoints in this behalf. This memorandum shall be accompanied by a copy of the decree appealed from and of the judgment on which it is founded. The memorandum shall set forth concisely and under distinct heads the grounds of objection to the decree appealed from without any argument or a narrative, and such grounds shall be numbered consecutively. Question: what is pro forma defendant? Answer: a defendant to a suit against whom a relief is claimed is called a pro forma defendant. A person may be added as a pro forma defendant in a suit merely because his presence is necessary or for a complete and final decision of the questions involved in the suit. What is necessary and proper party? Answer: a necessary party is one without whom no order can be made effectively. A proper party is one in whose absence an effective order can be made, but whose presence necessary for a complete and final decision on the question involved in the proceeding under Article 156 of the First Schedule or the Limitation Act. Question: what is the limitation period in civil appeal? Answer: according to Limitation Act 1908, an appeal against decree or order can be filed in High Court Division within 90 days from the date of the decree or order appealed from. Question: how do you arrange the memo of appeal? Answer: no notice page needed, no index needed. First page of the petition will not be numbered. The power wakalatnama will go at the end of the memo. There will be no back page and no submission needed. There will be grounds only, no affidavit needed, no annexure, but you will add the copy of judgment at the end of the petition, but before wakalatnama. You need certificate. Question: what is the order of memo of appeal? Answer: number 1, court fees stamp will be placed on top of the memo. Number 2, memo of appeal. Number 3, wakalatnama. Number 4, judgment and a decree of order. Number 5, a typed copy of judgment and decree if needed. What happens after the admission of appeal? Answer: assuming your file of appeal is in the court and your matter is called, you will make submission in favor of admission of appeal. Usually the court will admit appeal because you have given court fees. However, if you have condonation prayer, you will also have to make a submission in favor of condonation. If the delay is content, your appeal is admitted. Question: what is civil revision? Answer: civil revision may be of two major types. Number 1, revision against an order, and number 2, revision against judgment and decree. Question: what is the nature of civil revision? Answer: civil revision is a motion matter. Like any appeal, you have to file the petition of revision within the limitation period in the respective section. Unlike civil appeal, a second revision is possible under subsection 4 of section 115 of the CPC. What is the limitation period of civil revision? There is no mention of limitation for civil or criminal revision in the first schedule of the Limitation Act. The widely held view is that the period of limitation for civil revision is 90 days from the date of signing the decree by the judge. Article 173 of the first schedule of the Limitation Act is considered to be appropriate for civil revision. Question: what do you know about jurisdiction, single bench or double bench, with regard to civil revision? Answer: you need to know whether you will file the petition for a single bench or double bench. This depends on the value of the suit or appeal. If the value is less than 4 lakh taka, then it will go to the single bench, and in that case you need to file only one copy in blue paper, revision application in the court. On the other hand, if the value of the suit and appeal is at 4 lakh taka over or more, then it will be submitted to a double bench. Question: what is counter affidavit and when do you need it? Answer: if you are working on behalf of the respondent, you need to prepare a formal reply, also called counter affidavit, which you will have to file in the section before you take the civil revision on the civil revision on the list for final hearing. After filing in the section, you have to serve a copy to the petitioner's lawyer, and the petitioner's lawyer will receive it acknowledging on the main petition. Thank you, viewers.